what we call relevancy. We're interrogating relevancy and admissibility of evidence. So for today, we'll be introducing the topic. Remember that in our last class, when we looked at the meaning of evidence and the classifications of evidence, I noted that relevancy is the hallmark or the basis of admissibility of evidence. That was where I was, making the point that when you go to court, because our court is a court of law, our court is a court of evidence. When you go to court, before the court gets to even determine the applicable rules, the applicable laws, it is fact first, then law later. So it is when you have been able to establish that this is what happened, this is what happened. That's now when the court will now look at it and say, okay, what does the law say about this? It is like what Timi Agbajiwo does. When he says, what does the law say? And when you look at it, most times, Timi Agbaji speaks to social or trendy issues. So which means it comes to tell us what the law says about a particular happening, about a particular event. Something has already happened. So he's not asking, what does the law say? So that thing that has happened is the fact. So what does the law now say about the fact is another thing. So when you go to court, you're meeting a judge that is supposed to be a referee, that is supposed to be an impartial umpire. So the judge was not there. So the judge cannot say whether it is the claimant that is speaking the truth or whether it is the defendant that is speaking the truth. The claimant is saying this is what happened. The defendant is saying no, that was not what happened. Though. This is what happened. So at the end of the day, the judge was not there. So the judge cannot just say, oh, I love the claimant, so I'll just take your own version of the story, the account of the event. Or, oh, I love the defendant, I'll take it. Or I love the prosecution, or I love the accused person. No. The judge will only be able to determine what happened by reason of the evidence that has been adduced. So what the evidence that you are bringing, what exactly is the purpose of the evidence? The purpose of the evidence is to prove facts, to say this is exactly what has happened. This is not what happened. Oh, you said that what I cost you. So where is the proof? Where is the evidence? You said I stole the money. Where is the proof? Where is the evidence? In fact, yesterday I was in a meeting where, there were allegations here and there also about people that were there. Some of them made some statement. Then there was a particular man that made a statement. He said, the law, and that was in reference to me. He said, the law. Mulima Kawil, that is, I might not be a lawyer, I might not probably have not have studied law or have any legal background, but I have common sense. And I said, of course. So I said, yeah, when somebody makes a claim to say this, exactly, we can't just expect us to just take it like that. Where is the evidence? So, we started bringing in evidence here and there. It is to prove fact, to say this thing that we said happened, indeed happened. So when you go to court, you also adduce evidence, you canvass evidence. But the evidence you're bringing to court, you're not just taking it to court for, for taking sake, if I may use the expression. You're taking it to court for a particular purpose. What is the purpose? To prove facts so that the court can now apply the law to the fact. So what we now want to interrogate today is that when you now take evidence to court to prove facts, there are some times that you will take a piece of evidence to court. And when the court looks at it, the court will say, what this piece of evidence, what exactly do you intend to use it to prove? And you may tell the court and say, this is what I intend to use it to prove. And the court may look at it and say, see, this is not relevant. It doesn't help what's the case. There is an issue here. Why have you sued this person? Let's say it's a civil case. Say, I've sued this person for the thought of assault and battery. So the thought of assault and battery, basically, more or less, you want to show that this person has put you in reasonable apprehension of fear. He did something that made you to be scared, to be worried, that you had anxiety, or this person made unlawful contact. So that is exactly what thought of assault and battery, that is trespass to person, is. So when you want to now bring evidence, you should be bringing those evidence that will prove the fact in terms of what this person did that put you in reasonable apprehension of fear, Fact in terms of how you indeed was even what scared, or maybe you were not even scared, but a reasonable person would have been what been scared. Fact of saying that what this person did is direct, that is, he did it directly. Fact of saying that what, oh, it was not more or less something that he did, or maybe made a statement that showed that okay, it was not going to cost me any harm at that particular time. That, oh no. Or when you say battery, you should at least also show us that touch, the contact, and then you should be able to show us that it was then what unreasonable, it was unlawful, it was it was unjustifiable. So it is when you bring this evidence, that is now when you can say that it is relevant, because it helps you to prove your case. It helps you to prove why you are in court. Because if you are canvassing a piece of evidence, don't forget that I said evidence is used to prove facts. It is when the facts have been proved, that is now when we apply the law. So when you say that somebody has committed a crime, or you say that somebody has committed a civil wrong, whether it is a civil wrong or it is a crime, there must be a law. It must be that the person has breached a law, maybe a civil law or a criminal law. So the law would have contained some ingredients, certain things that you need to prove before you can claim that that person has breached that law. So in that regard, the question will now be the evidence that you are bringing. Would they help you to prove those elements, those ingredients of what? Of the offense or of the civil wrong? Now, to also put it in context, when you're taking an exam and you see a problem question, see, problem questions are also not just set, or you're not just examined using problem question for the sake of it. Problem questions are designed to achieve several purposes. And one of such is to also help you appreciate how to merge facts with what? With law. And that is the reason you see that in the problem question, when you look at the problem question, the first thing that comes to your head is for you to be able to determine what law applies. Is this problem question dealing with maybe the crime of stealing, or is it defamation, or is it a breach of what? Contract? Is there a mistake? Whatever area of what? Area of law. But you need to quickly know that the sum of the fact, you need to know what area of law what it is. Then, you start by saying, okay, you raise your issues. Then you start by expounding on the laws, that is the rules, this law, because you already know that from the story, the fact I've shown that, okay, it is this particular aspect of law. Now, when you have now set out the law, there is now the application, where you now say, in applying the above rules or the above laws, or in application of the above rules or above laws to the what? To the instant what case. You can be seeing that what? So person did this, and doing this proved what? This element of the thought, or this element of what? Or ingredient of the offense. So if there is nothing, so at times you will read a problem question, and as you are reading, it's not all the things that they wrote there that are relevant. Some of them are there to just ensure that at least there is no disconnection in the story, in the fact. So when you are reading a problem question, you are more or less concerned with those facts that you know that what they have to do with the law, that you know that they will help you to prove whether a person has been guilty or not guilty, or whether a wrong has been committed or what or not. So which now means that what? As you adduce evidence to prove what? Fact. But the question now is it all the evidence that you take to court that would be admitted? Now, when you take what? Evidence to court, it doesn't mean that the court will accept it. Like carry all different, it does not mean that the court will accept it. So there are some pieces of evidence that the court will reject. So the question is, what are those pieces of what? Evidence that the court is meant to admit? That is, the court is meant to accept and say, yes, we can we can take in this piece of evidence, and we can rely on it to determine the fact, exactly what happened. So what the law has now said so far is that, well, for any piece of evidence to what? To be admissible, for the courts to be bound to admit any piece of evidence, then that piece of evidence must be relevant. It must be relevant. And that is the reason we say that what? That relevancy is the basis of admissibility. Which means that if a piece of evidence is not relevant, then there is then the court is not expected to admit, that is to accept that piece of evidence. If you look at what happened in the case of candidate John versus Edgin, Candidate John versus what? Edging. A minute. Look at what happened in Candidate John versus Edges. Now, in that case, so let me see if I can write it out there. Um, so the case of Candidate John versus Edges. Edges is spelled Edgis. So in Candidate John and Edges, what happened summarily in that case was that there was a trial at you know at the magistrate court, and in the applicant of this candidate John himself, he moved the motion, and the magistrate was then like, oh, that was going to adjourn the motion for ruling. So which means that he didn't really give his decision on that day. He already adjourned. But then somehow in the course of the proceeding, the magistrates had cause to ask the counsel, the lawyer, that when did you finish from from law school? But it appears that that question was asked in a rather humiliating, embarrassing, and rather pejorative manner. So the counsel took offense, to that, and the counsel responded by saying that he was not going to answer that was question in the rudest manner. So the magistrate considered, the counsel's answer, that is response or reply, so to say, as contemptuous. And as a result of that, the magistrate ordered that the counsel should be detained for a particular period of time. So when the counsel, secured his freedom, he instituted a fundamental human right action on the basis that what his fundamental human right had been violated. And, among other matters that the Court of Appeal had to, determine, one of them was to ask whether the question that the magistrate asked, the question as to when the counsel finished from law school, whether it was relevant to the issue before the court. So, and the court looked at it. The court said it was not relevant. So, if it was not then what relevant, then it is not something that you should be taking in as evidence. It was not relevant. What they were trying to resolve had nothing to do with when the counsel finished from law school. It would have been a different situation where, if, for example, you're in court and now let's not assume that there is a reason to call a matter out of turn. Now, calling a matter out of turn is basically more when you go to court ordinarily. You check the cost list. So when you check the cost list, you look at the matters that are listed. So those matters that are listed are the business of the court for that day. So if your matter is not listed, that means they won't call your matter on that, at least on that day. So when the matters are listed, they are numbered. So which means 1, 2, 3, 4, 5. So number one case would be called first. So there are times that you may want your matter to be called out of turn. So which means that maybe you are number 10, but you want them to call you as the first person. So, of course, it's a privilege. So there are certain persons that are entitled to these privileges. So one of them would be, say, Senior Advocate of Nigeria. So now, assuming that we have 2 Senior Advocates of Nigeria in court, and both of them want their matter to be called out of turn. Now, both of them are already entitled to this privilege, because they are both learned 6. So the question now is, who gets to go first? Whose matter gets to be called first? Now, in that regard, the court may want to say, oh, since both of you are Senior Advocate of Nigeria, the court may want to look at who is senior at the bar. Senior at the bar in the sense of the year of call. You understand what I'm saying? A year of call. Or they may look at the year in which they were conferred with the title of Senior Advocate of Nigeria. But the court may also look at the year of call. So in that regard, if the court now asks and say, Learned Sick, please, when were you called to bar? In that regard, that question is relevant, because what the court needed to resolve, the dispute, the issue the court needed to resolve was who gets to have his matter called first. And that can only be determined, since both of them are Learned Sick, by, say, maybe the year of call. Or in a situation where the court is suspecting that a counsel before the court, that is a lawyer before the court, is a quack, that is, had not been called to bar. It wouldn't be out of the ordinary if the court then ask and say, okay, if you say you are a lawyer, when were you called to what? To bar? In that regard, that question is relevant. So any evidence to prove that, yes, would then be relevant. But in a situation where there was nothing of such, this person moved a motion, and then the next thing is because you wanted to make a snide remark, you then ask when, or whatever you call to what, to the bar, and he didn't respond, and you held him in what? In contempt. So it is very important that when you approach what? The court with evidence, you don't just take any evidence that you fancy to court. No, you don't take any evidence that you fancy to court just because you fancy a particular piece of evidence and you just take it to court. No, you have to ask yourself, is this piece of evidence relevant? Because if it is not relevant, the court is not going to admit it. That's why we say that what? Relevancy is the bedrock of admissibility. And what does that mean? It means that what? For any piece of evidence to be admitted by the court, to be accepted by the court, that piece of evidence must be relevant. That piece of evidence must be what? Relevant. Please confirm to me that you are following me so far and that you understood what I've said so far before we proceed further.
I think I do.
You think what?
I understand you were hammering on the point that relevancy is the bedrock of admissibility.
Now put it in simple language that you understood it. That was what I said. So what did you now understand that to be?
Mm.
So supposing you, okay.
For evidence to be admissible, it has to be relevant.
Yes. So which means
So,
if you bring any piece of evidence, the court will not just take it from you like that, hook, line, and sinker. No. The court will have to ask, okay, is this relevant? And the court will look at those ones that are not relevant to the case, and then they'll put it what? Aside. Do you understand what I'm saying? Look at and say, and put it what? And put it aside. So have you ever been in a situation where they ask somebody a question? The question is clear. But when the person starts what? Answering, you start squinting. You understand what I'm saying? You start to what? To squint. You start to raise your brow like, okay, what did they ask you? What are you all saying? And at some point, you just be like, this thing now that you have not said, how is it related? How is it related to what they asked you? Essentially, what you are saying in this answer that you gave now, how is it relevant to the question that you have been asked? So that how is it related? The way you are confused, you are like, okay, why are they asking you hey? And you are saying it was Z. They are not related, they are not connected. Essentially, they are not relevant. So you may bring what? A piece of what? Evidence, and at times you're like, this one now that you have not, what is it supposed to prove in the issue in court? Is that understood, please?
yes, please.
All right. So now the question now is, what now determines whether a piece of evidence is relevant or not? Since relevance is the basis or the bedrock or hallmark of admissibility, what then determines whether a piece of evidence is relevant or not? Is a piece of evidence relevant simply because AOC considers it relevant? Or simply because a man feels like what? It is relevant? Or is it not relevant because a man feels that it is not what? Relevant? So what determines whether a piece of evidence is relevant? If I'm arguing that this piece of evidence is relevant, and Precious is arguing to say no, it is not relevant, so the court should not admit it. The question is, what then determines whether any piece of evidence is relevant or not relevant? Now, to this question, the learned Sikh, Professor Sagi, has argued. He said that what determines relevance is generally the law. That is the law. That is whether a piece of evidence is relevant or not. We have to go and check maybe the Evidence Act, or we go and check maybe any other statutory provision that says it is what? Relevant. And he also proceeded to say it is not only the law that makes what? A piece of evidence to be what? Relevant. He said logic and common sense too can also make what? A piece of evidence to be relevant. So Professor Issesage contends that Relevancy is determined primarily by the law, but also by common sense and logic. And in a sweeping counter position, Professor Aguda Professor Aguda maintains that relevancy is strictly a matter of law. Professor Aguda maintains that relevancy is strictly a matter of law. Now, what is the difference in the contentions between these two legal doings? The difference is that while Professor Sagi believes that aside the law, logic and common sense may also determine relevance, Professor Aguda insists that whether a piece of evidence is relevant or not is strictly a matter of law. It's not a matter whether you are using logic or common sense. It is a question of whether the law says that what it is relevant and no other consideration. In fact, Professor Aguda proceeded to even say that when you look at the Evidence Act, that you will see that the Evidence Act has provided the rules that govern whether a piece of evidence is relevant or not. And that's true. But in our next class, we'll look at those rules, I think from sections 4 to 13 of the Evidence Act. Yes, sections 4 to 13 of the Evidence Act. They are the principles, they are the rules that govern when a piece of evidence will be deemed to be what? Relevant. So Professor Aguda's own position is that when you look at those rules, and these are the laws that he was talking about, in sections 4 to 13, that you will see that they are also based on common sense, based on logic. That is, even though it is a provision of the law, the reason section 4 is saying that a particular piece of evidence in that circumstance is relevant is also because it's only logical that what such should be relevant. But his own argument is that just because those laws are based on logic doesn't necessarily now mean that what you now say logic is also a basis for determining relevancy. At the end of the day, these are still the laws. Anything outside the law, then that piece of evidence will not be what? Will not be relevant. So whether you align with what Professor Sage's position or with Professor Aguda's position, one thing is clear, and it is that whether a piece of evidence is relevant or not is determined by engaging and interrogating the law. And the law here could be the Evidence Act. The law here could be any other statute. But for the purpose of this class, we are going to limit it to the Evidence Act because the Evidence Act is one that provides the general rules or the general principles for determining whether a piece of evidence is relevant. So what have I said in a nutshell so far? The first that I've said is that when you go to court, you are supposed to prove what? Your facts. And you do that by evidence. The second thing I've also now said is that just because you canvass evidence before the court does not mean the court is going to admit it. For the court to admit a piece of evidence, that piece of evidence needs to be what? Relevant. The third thing I've also said today, or the third point that I've also made today, is that whether a piece of evidence is now relevant or not is determined by the law. So which means that for the purpose of your Evidence Act, if I ask you whether a piece of evidence is what? Relevant or not relevant, after the classes that we are going to have on this topic, because this is not going to be the only class, after all the classes that we are going to have on this topic, if I now ask you, or if I give you a scenario, and you are to determine whether a piece of evidence is relevant or not, you are not to answer me by applying logic, by applying common sense. You are to answer me by saying that this is what? Relevant because section 5, or because section 6, or because section 7, or in any of those what sections says that what? It is relevant. Is that understood, please? Is that understood though?
Yes, it is.
All right. Now, when you now see that, you see that the general idea is that any evidence that is sufficiently relevant to an issue before the court, any evidence rather, that is sufficiently relevant to an issue before the court is what? Admissible. And it means that any evidence that is not what? Relevant is inadmissible. is inadmissible. And on this, I would want us to open to section 1 of the Evidence Act. See, like our company law that you cannot do without your comma, the Evidence Act as well, you cannot do without what? The Evidence Act of 2011 as amended in 2023. So this is our copy. I expect you to have your copy here. Or you come and get your copy what? Yeah, we have copies here that you can get. So, does anyone have the Evidence Act? Like with you at the moment. I can read out for us, section 1 of the Evidence Act. Now, I've told you, I said the classes are going to be student-centered. So even to the point of reading out sections or any other thing, this is something that I've decided to outsource towards to you students. So anyone with Evidence Act there to read out section 1 for us? Wait, nobody? I swear to... Okay, let me not swear. So, is it only you that you now have? Wait, so only what? We face this same thing when we had company law. That was how I got frustrated because just I don't understand. Are you people not ready? If you're not ready, I'm not ready. We've started this class for like 2 weeks now. Whether soft copy, whether hard copy, you do not have. I don't understand. Are you people thinking that you come and I'm supposed to just do everything? And all you have to do is to like listen, because this is like maybe the third or fourth class you're having on what and everything. Soft copy you did not have. So I'm supposed... Section 1 of the Evidence Act says that evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue, and of such other facts as are hereafter declared to be relevant, and of no others. Now, when you look at the wordings of section 1, and I wonder how it will make sense to you people that I'm reading and you don't even have the act for you to even follow. But at this point, I don't think, at least as far as this class is concerned, I don't even think that the enthusiasm and everything that I had in taking the class, not me. Oh. All right, from the words of section 1 of the Evidence Act, when you look at it, you see that it kept saying that evidence may be given in any suit or proceeding, that is in a case, of the existence or non-existence of every fact in issue. So what section 1 is basically saying, that you can go to court and you can bring evidence to show that a particular fact existed. So if, for example, you said I slapped you, you can show the court to say that that fact existed, the fact that I slapped you. So you go to court, maybe you add an eyewitness, somebody that can come and give oral account. Yes, I was there, oral testimony. Yes, I was there. That is to show that, yes, that fact that I slapped you existed. And you can also go to court to also adduce evidence to discountenance the fact. That is to show that what the fact did not exist. So which means I will now be saying I did not what? Slap you. So maybe I made an attempt where I didn't touch you. So you are to bring your own evidence of I slapped you. I am to bring evidence to say, no, that fact never what? Existed. Now, it said evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue. So now it doesn't just say fact, it says fact in issue. So it's very important, please, that you know that, or as you come towards to learn in this class, that there is a difference between facts and also what? Fact what? in issue. So which means that you may bring a piece of evidence that shows what? A fact. But that piece of evidence may not prove the fact in issue. That piece of evidence may not prove what? The fact in issue. It proves the fact, but it may not prove what? The fact in issue. So if and let's say, for example, this is the issue of whether I slapped you or I did not slap you. That is a fact in issue because that is the question that the court wants to answer. Whether I slapped you or I did not what? Slap you. That is what the court wants to answer. So any evidence to show that I slapped you or any evidence to show that what? I did not what? Slap you is actually what? A fact in issue. But if somebody is not bringing in evidence to not say that, hey, but Ori David loves how, there is evidence to show that yes, Ori David loves her. That is, yes, it's facts. There's at least you have used evidence to prove, assuming you're able to use evidence to prove. Now, that is fact. But the question is that really the fact in issue? It is peace, yeah, it's a fact. The evidence shows yes, but is that really the fact in issue? Is that really what we need to resolve in this case? So when you look at section 1, when it says that you may bring evidence to prove the existence or non-existence, it's not just say the existence of facts or the non-existence of fact. That's not what you are proving. What you are proving is that you can use a piece of evidence to prove the existence of facts in issue or what? The non-existence of facts in issue. So when you go to court and in the course of this semester, we are going to have a simulation, something like a mock trial. So it would involve you having to try to adduce evidence. So what should ring in your head when you want to adduce evidence is not, let us adduce evidence, let's canvass evidence to prove facts. No, you canvass the evidence to prove what? Or to disprove the facts in issue. So when you read section 1, it basically says that you can use evidence to prove fact and to prove fact in issue. Then he proceeded again and said, and of such other facts that are declared to be relevant and no others. So which means that what section 1 is basically saying is that you bring evidence to prove either a fact in issue or to prove any other fact that the law has declared to be relevant. So maybe the fact that you are bringing the evidence to prove is not necessarily the fact in issue, but maybe there is a section of the Evidence Act that has now said that that fact is nonetheless relevant. You can still use the piece of evidence to prove that. So use piece of evidence to prove either the fact in issue or any other relevant fact that the law says is relevant. Is that understood? Now, when Professor Sage interpreted this section, that is this section, of course, his article was actually based on the former Evidence Act, so not the 2011 version. So he was interpreting section 6 of the Evidence Act of 1990. But now that section 6 is now the section 1 of the Evidence Act. So we'll be referring to it as section 1. But when Professor Sage interpreted, this section 1, the equivalent as at that time, his conclusion was that he said that 2 pieces of evidence are admissible by reason of this section. He says evidence of fact in issue and also evidence of other facts that are relevant to the fact in issue, which is not excluded by the law. Now, this is what I'm saying. What I'm saying is that according to what? To Professor Sage, when he interpreted, it was formerly section 6, but not to confuse you, since section 6 is also more of section 1 of the Evidence Act. He says that the import of that section is that when you bring evidence to court, you use it to either prove, he said 2 pieces of evidence would be admissible. One is evidence of facts in issue. And then he said aside what? Aside the evidence of fact in issue. So he said the second is any evidence that is declared relevant by is declared relevant by the what? By the law. So which means that the evidence may not necessarily be about the fact in issue, but maybe there is a section of the law that still says it is nonetheless relevant. And in the course of this class, you would learn exactly what that means. Is that understood, please? Now, we have settled it that for a piece of evidence to be admissible, it must be relevant. And we have said that whether a piece of evidence is relevant or not is determined by the law. So we are still going to look at those general principles on relevancy, that is, those instances where a piece of evidence would be relevant, so that when it is now relevant, it can now be admissible. So relevancy first before admissibility. Don't jump to admissibility. You must have proved that what it is relevant simply because there is a particular law that says that what it is relevant. So that is that. But we'll look at also the question whether every relevant evidence is admissible. So just because a piece of evidence is relevant does not mean that automatically the court must admit it. We'll come towards to that later. But for now, let it be settled in your mind that for a piece of evidence to be admissible, then it must be relevant. Now, in interpreting this section 1, this is Professor Sage's interpretation of the then section 6 and now section 1, which is that it says, what he's basically saying is that you can adduce evidence in court to prove the fact in issue or to prove any other fact that the law has declared relevant, even though it may not be the fact in issue. Now, remember the scenario I painted. The scenario of whether Ori David slapped you or not is the question the court wants to answer. That is a fact in issue. Yes. Now, when we say fact in issue, it means that is one fact that is that is still being disputed by the party. In issue means what? In dispute. Do you understand what I'm saying? It's a fact in dispute. And when we say a fact in dispute, it means that somebody is saying this is it. Another person is saying that is not the way it is. So it is not a settled fact yet. So you may have a fact. So Ori David loves what? So person. You brought evidence. Yes, that one is settled. It is a fact. But it is not an issue because nobody is contesting it. So that is why section 1 is saying that when you take evidence to court, ensure that you are either using it to prove what? Fact in issue, or you are using it to prove what? Any other fact that the law has said is relevant, even though it may not be the fact in what? Issue. Now, Professor Aguda also now conceptualized this same section 1. Professor Aguda also conceptualized section 1. And what did he say? Now, according to Professor Aguda, he says that as a general rule, it is only facts that are relevant to the fact in issue. As a general rule, it is what? Only facts that are relevant to the fact in issue. 1, only facts that are relevant to the fact in issue. Or some other facts relevant to the fact in issue that can serve as a foundation for the admissibility of a piece of evidence. In other words, evidence will be admitted only in proof of. Now, Professor Aguda says evidence that you are adducing before the court will be admissible only in proof of. So, only what? In proof of. What's the first thing? Only in proof of 1, facts in issue. 2, facts relevant to what? Facts in issue. Facts that are relevant to the facts in issue. You can use evidence to prove fact in issue. You can use evidence to prove facts that are relevant to. So, like, the evidence you are bringing is not necessarily proving the fact in issue, but it's proving one other fact that is somehow still connected to the fact in what? In issue. Then 3, he said you can also use evidence to prove what? Facts relevant to some other facts. Facts relevant to some other facts. Facts relevant to some other facts in issue. At the end of the day, look at this. Facts in issue. At the end of the day, look at this. Facts in issue. at the end of the day, still look at this. Facts in issue. So the three pieces, or in terms of the nature of the evidence that you are adducing, that is admissible, all of them somehow are related or connected to the fact in issue. Is that the evidence touches on the fact in issue directly? Evidence that shows I slapped you. Somebody recorded this when I pop. You understand? When I did, more days here, pop. That one, it's evidence of what the fact in issue, because what the court needs to what to determine is whether I slapped you or not. Okay, you are still here. Then he said the second one is the what? You can also use evidence to prove facts that are relevant to the fact in issue. Facts that are relevant to the fact in issue. So if, for example, the issue is whether I slapped you or not, that is the fact that is being disputed. I said I didn't slap you. And then somebody also now said, and you are saying that I slapped you. Then if I now bring evidence to now show that you said I slapped you, and you said I slapped you with my right what? And I now bring, maybe a medical report, God forbid, that now shows that, no, I have a medical condition where I cannot even lift what? Or my enemy cannot even lift what is right and you have said that I slapped you with my right hand. You want to be looking at it and say, what is the essence of a medical report? This piece of evidence now that you want to determine, how does the medical report directly show us whether Orilevi slapped you or not? My response would be, yes, this may not necessarily prove the fact or disprove the fact what an issue. But somehow it is still relevant to the fact in issue, because the issue whether I am able to, use what? My right hand or not is still relevant to the issue of whether I slapped you or not. Because if I cannot use what? Right hand, then clearly there's no way I could have slapped you. So somehow the piece of evidence may not directly be connected to the fact in issue, but it may be connected to one fact that is still connected to the fact in issue. So that's what I mean by what? Fact relevant to the fact in issue, or fact relevant to some other facts in issue. That is, you could also have a piece of evidence that is also not directly relevant to the fact in issue, is relevant to another fact. But when you look at that other fact is also still relevant to the fact in issue. So these are the three instances. At least this is Professor Aguda's interpretation of section 1 of the Evidence Act. But at the end of the day, what is clear here is that section 1 is basically saying that you can adduce evidence to prove or to disprove the existence of fact in issue, fact that are relevant to the fact in issue. It still has to be somewhat connected to the fact in issue, or to any other fact that the law has declared to be relevant, even though it may not necessarily be connected to the fact in issue. Now, when you look at the analysis so far, it then means that there is no way for us to start talking about relevancy and not talk about fact in issue, because it is thus clear that any piece of evidence that has no bearing with the fact in issue may then not necessarily be relevant, because at the end of the day, what you are proving directly or indirectly is the fact in issue. So that then makes it pertinent that we then also interrogate the meaning of fact in issue. Like, what does it now mean? Okay, you take, I knew I made an illustration, but let's also look at it even more, elaborately. What does fact in issue, what does it even mean? Yes, we said there is fact. We said there is fact in issue. What is even fact? And how do we distinguish it from fact in issue? Of course, you have to know fact first. Fact in issue is a type of facts. So when you know what a fact is, then that is now when you can now determine whether it is an issue or not. It is a fact that will be an issue. So if it is not a fact in the first place, then it cannot be an issue. Are we together, please?
Yes.
All right, thank you. Now, I said, if a fact is an issue, it is relevant. If a fact is in issue, it is relevant. If you can prove that a particular fact is an issue, then any piece of evidence that you want to adduce to prove that fact an issue is relevant. I can show my lord and say this fact is an issue. In fact, when I was in court today, earlier today, you know, in one of the matters, not ours, but I can remember that I think the council was talking about bringing an application for an application to regularize their processes. To regularize was more of they had already filed, but then they now wanted to like amend what they had already filed. So you needed the leave of court. So they brought an application that okay, please so allow us to amend so that once the court has granted the application, they will now amend, they will change something. And I think my lord was asking and saying, okay, what are those things that you wanted to? And they said that it was some documents that they did not annex to their initial, process, and that they need to add this document more as as evidence. And my lord has said, these documents that you now want to add now, that you are asking for leave to amend now, do you think they are relevant to the substance of this case? Would we not be able to dispose of this case in the absence of this document? And the council say, my lord, this document proves this, it proves that. Without it, it may be very difficult for us to prove the case and like resolve the issue between the two parties, that is the claimant and the defendant. And I think when my lord also interrogated these documents, perhaps my lord also considered them to be relevant. That was now when he allowed them. So, which then means that what? Any piece of evidence that you want to adduce, once it directly touches on the fact in issue, then it is what is relevant. So once a fact is an issue, that is, a fact is being disputed, claimant said this, defendant said that's not the way it happened. We entered into what? A contract. Defendant said, yes, we entered into a contract. That is not a fact in issue. It is a fact, but it's not an issue. It's not an issue because both parties agree to it. So fact in issue. And I said in issue there should be seen as dispute. So you can say fact in dispute. Instead of saying fact in issue, you can say fact in dispute. That is that thing, that fact that both parties disagree upon. When we registered the company, I was the one that registered the company. And the other party said, yes, you registered the company, but it was with my consent that both of us should be members of the company. And he said, no, we never had that arrangement. We never had that agreement. Look, both A said, I registered the company. B said, yes, you did. That one is not a fact in issue. It is a fact because they can bring evidence to show that that was exactly what happened. But it's not an issue. But A proceeded to say, no, B now said, when you registered, it was because I gave you consent to register and I said you should register both of us. B now said, no, we never had any such arrangement. That is one that is an issue. When they go to court, the question is not whether A registered it. That one is settled. The question would be whether when A was to register, B and A had the understanding that both A and B would be made to be shareholders in the company. So maybe A had registered only himself as a shareholder. And B is saying that I'm also supposed to be a shareholder. So and A is saying, no, that is the one that is in issue. That is the fact that is in dispute. That's why they are in court. If they were not in dispute over that, they wouldn't have come to court in the first place. Please, are we together? Exactly. So it's very important for us to know what a fact in issue is. But before we know what a fact in issue is, because a fact in issue, as I said, is a type of fact. So we can have a fact in issue. We can have a fact that is not in issue. So it then means that we should at least first even understand what a fact is before we now start to know the one that is in issue. So what is a fact? The Evidence Act has defined a fact. So we are not going to limit it to our own perception. According to Section 258 of the Evidence Act, and the Section 258 of the Evidence Act is the interpretation section. So most times when you need to know the meaning of a particular word or expression, you may make recourse to section 258 of the Evidence Act to see whether it has been defined or not. Now, according to section 258 of the Evidence Act, it says what? It says fact includes. It did not just say fact is. Now, you know that in law, the moment this expression is what is used, includes, it means that whatever is now adumbrated, itemized, they are not exhaustive. So that means that what? The meaning that will be ascribed to that particular word or to that particular expression or phrase will not be limited to what has been stated. It can go beyond it because it includes it. It is different when you say fact means or fact is. So it says fact includes anything, state of things, or relation of things capable of being perceived by the senses. Anything that you can perceive by the senses. Oh yeah, please, you guys, remind me, your days of, was it biology? How many organs, or sense organs rather, not organs, how many sense organs do we have in the body? Oh yeah, balance me real quick. How many sense organs do we have in the body?
I think 5.
What are the 5?
Eyes.
The eyes.
Yes. There's nose.
Nose.
There's ear.
The ears.
There's tongue and there's skin.
The tongue. And what? The skin. Precious, do you agree? Is Precious not on the call? All right. Now, so these are your sense organs. The eyes to see, the nose for you to be able to smell, to perceive, the ears for you to be able to hear. At times when I say, can you hear me? Just to, to be sure that what? Your ears are working. You have the tongue for you to taste. And then you have what? The skin for you to feel. So when I hit you on your hand, your neurons, there, we quickly send what? A message to the hypothalamus in your brain. And the hypothalamus will quickly interpret it and say, this is pain. And that is now when what? You now manifest that expression of what? Of pain. So, what section 258 is saying is that, see, whatever it is that you can see is a fact. That's why we say eyewitness. Whatever you can see. They say, yeah, he beat him. He did it. Were you there? Did you see him? He said, no, he did not see him. Yes, I saw him. I was there. That is what? A fact. So anything that what you can see is a fact. That's what section 258 is saying. The nose, for it to what? To smell. Anything that what you can what? Smell is also what? A fact. That is the reason when you accuse someone, you have body odor. You know what? Wear what? Roll-on. Also deodorant. Also whatever. And the issue is now, does the person have body odor? The person wear roll-on? When you say, yes, I was there. And the conductor did this or that. That is what? A fact. You also have what? The ears. Anything that what you can hear is a fact. This class held blah, 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 would be a fact for the very reason that what you can see that the class was holding. For the very reason that what you can hear. Of course, you cannot what? Smell anything because you are not here. But you can what? Also hear or read everything. That is what? A fact. Said, yes. He raped what? Her. So how did you know? Said, I was in the other room where I heard her screaming, no, leave me, calling what? His name and blah, 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 also whatever. Yes, you can be brought in as what? As a witness to come and give evidence of that fact. The question will not be whether that fact is what? That's another question, whether it is not an issue, but at least you prove by saying that I heard this. It's what? Can use it to prove a fact. Then, a fact is also anything that what? That you taste. Because that's also one of your what? Sense organs. Think about what? Taste. It's also what? A fact. Then the skin, what you feel. So the whole thought of say battery, you'd also have to do with what? This. So anything that you can see, anything that you can smell, anything that you can hear, anything that you can taste, and anything that you can feel is a fact. According to what? To section 258 of the Evidence Act. Then if you look at what? Paragraph B of that same section, it proceeded to say any mental conditions of which any person is conscious is also what? A fact. Mental conditions. Now, this is not about the sense organs alone. We're not looking at what? The cognitive faculty. Any mental condition. Is this person normal? The person suffering from insanity? The person suffering from automatism? All this would also be what? Would be a fact. So, as I also have it here, I said, different facts come before the court. Different what? Facts will come before the court, but only a fact in issue is to be pronounced upon by the court. So you can bring facts, but the question will now be whether it is actually in issue. She's a beautiful lady. Nobody is contesting that with you. So what are you bringing it to court? It is if they're not saying that no, she's not what? Beautiful. No, that one is now what? An issue. That is the one that you should be bringing evidence to prove. I mean, she's beautiful. Nobody's challenging that. You are bringing evidence to prove that, she's beautiful. That's not an issue. Bring evidence to prove what? The fact in what? In issue, or any fact that is relevant to the fact in issue. So, when we now already know what fact is, then the next question now is, what does fact in issue now what mean according to the law? What does what fact in issue now mean according to the law? Now, when you look at the same section 258, after defining fact, the next, and you just cast your eyes down, you will see fact in issue. All these things you're supposed to be following me, looking at what the evidence or acts. Now, when you look at section 258, it says fact in issue includes any fact. It also says includes any fact. You see, fact in issue includes any fact. That is, a fact in issue, or what I call a fact in dispute, is at first a fact. It must first be a fact. It is because it is in dispute, that's why we now ascribe that term, fact in issue, to what? To it. So, a fact in issue is still a fact. It's a type of what? Fact, so to say. So it says a fact in issue includes any fact from which either by itself, any fact that's by itself, or in connection with other facts, the existence, the non-existence, the nature, or the extent of any right, liability, or disability asserted or denied necessarily follows. Basically, more of any fact that you can use by itself without adding more, or any fact that when you add it with other connected facts, you'll be able to use it to prove or to disprove that somebody has a right, or to show what? Liability or disability. That is a fact in issue. If you institute a fundamental human right action, you are claiming that you have a right to human dignity, and that what? Your right to human dignity has been what? Infringed upon. The question before the court is whether your fundamental human right to dignity has been infringed upon. That is the question. That is the fact in what? In issue. And why is it what? A fact what? In issue. It is because anything that you are saying about, what maybe the police did or so whatever about the fact, those are facts. But they are not necessarily fact in issue until you are able to say, looking at this fact, even by itself, the fact that they put me in this, they did this, they stripped me off, or blah, blah. All these things show that what? They have violated my fundamental human right to human dignity, which is a right that I have, and which casts what? Liability what? On them. Aguda, or Professor Aguda, explained. He said that facts in issue are all such facts, all the facts that a plaintiff in a civil case must prove in order to establish his claim. If you go to court and you say that what? You entered into what? A contract with someone, and that person has breached what? The contract. Oh, for somebody to breach a contract, there must be a contract in place in the first place. So which means that what? All those facts that show that there is a contract in the first place, they are also facts in issue. Because you need to, well, these are the facts that you need to prove for you to win your case. For you to prove that what? Yes, there has been a breach of contract. So fact about offer. Fact that shows what? That this person accepted. Fact that shows there was intention to create legal relationship. Fact that shows that what? There was a consideration. Do you understand what I'm saying? Fact that shows that you have capacity. You need to prove all this fact so that the court can say what? There is what? A contract. Now, fact that now shows what this person has done to have breached what? The contract. These are the facts that you need to prove to win what? Your case. If you are claiming that what? You are a shareholder of a company, and they say, no, you're not what? A shareholder. The question is, are you a shareholder or not? That is the fact in what? In issue. So what are those facts that what? That you need to what? To prove? Fact of you purchasing the shares. Because by virtue of section 105 of CAMA 2020, for you to be a shareholder or a member of a company with share capital, you need at least one share. So you must, if you do not show us any fact to show that you, maybe you they gifted you a share or you bought share, that you have what? At least one share to you. If you cannot what? Show us what? That, then you are not ready. You are not showing you can't prove the fact in what? In issue. So maybe you are bringing the share certificate. Maybe you are bringing what? The letter of allotment, or maybe you are bringing the register of members to show that your name has been entered in the register. Maybe you are bringing all those things as what? As fact. Or maybe you are bringing the company's memorandum of association or articles of association that also now what? Recognize you as a shareholder of the company. So that's why Professor Agoda says all the fact that you need to prove in a civil case for the plaintiff or the claimant to win the case or to establish his claim, they are the fact what's in issue. If they have not been admitted, because once it has been admitted, a fact admitted generally need not to be proved. Yes. Because it's not in issue. Did you do it? I did it. So why should we waste our time to prove whether you did it or not? But it's generally, as I said, generally need not to be proved because there are exceptions. So if the fact, anything that you need to prove for you to be able to establish your claim that has not been what? Admitted, then is what? A fact what? In issue. Has not been admitted expressly or by implication by the defendants, and also such facts that the prosecution in a crime must also prove in order to also secure what? A conviction. So I say fact in issue also include what a defendant must prove in order to establish his defense. Fact in issue also include what a defendant must what? Prove in order to what? To establish his defense. So if you are also the defendant, the fact that you need to also prove to what? To establish your defense is also a fact what? In issue. So if, for example, in a case of slander, the fact as to whether that person altered, the words alleged to be slanderous is a fact in what? In issue. So if somebody said, I heard I heard him saying that, yeah, bringing that person to come and say exactly what he or she heard is what? Is a relevant fact because it's a fact what's an issue. So in a criminal case also, for example, any fact that you need to prove, maybe the prosecution, any fact that you need to prove to secure conviction, you say that somebody has stolen, then you should be able to prove that either that it took something. So if you say somebody has stolen and you cannot prove exactly what you are saying he has stolen, you are just saying he has stolen. No, what did he steal? So at least as to what is stole, this is what is stole. You should be able to prove it and also show that, okay, whatever it is he has stolen is a thing capable of being stolen. Somebody saw exam script, he read what? The information. You are charging him for stealing the information, not necessarily even for the paper that is holding. Yes, you are saying that what did he say? He said the information. And how do you prove that he stole the information? You say, we caught him when he was what? Reading or peering into the exam paper. Okay, maybe that shows that what he, of course, had unlawful access to the information. But the question is, according to the law, information is generally not what a thing capable of being stolen. That would fall under maybe any other offense or a misconduct. So you should be able to show that, okay, somebody was either taken or converted and has done that fraudulently, and that thing is also capable of being what? Stolen. So in a murder case, for example, you were saying that A committed murder. So what are those facts? You have to show us that A killed what? B. You have to show us that what? B is indeed what? Dead. Or you have to show us that what? A intended to kill C, but unfortunately killed what? B. Or A intended to cause grievous bodily harm to B, and that led to B's what? Death. A was smiling. How does that? Maybe truly A was smiling. Yeah, that's a fact, but that's an issue. Because what is an issue here is whether A killed B, not whether A killed what? B as a psycho. Because why are you killing somebody and you are what? Smiling? If it's the question before the court is whether A killed what? B, maybe gruesomely, or A killed what? B and was like, maybe that would have been relevant for you to say, when he killed it, the way he was even laughing, it was not remorseful. But here, he just did A kill B. So any what fact that you now need to prove, or you are proving it by what? Evidence. In order for the court to convict what? A of murder is what we call a fact in issue. So if, for example, in the case of, say, maybe trespass to land, the plaintiff is accusing the defendant, or the claimant is accusing the defendant that you trespass upon my land. And the court said, how? Said, because you had unlawful what? Access what? To my land. You entered on my land without any justification. So what are those things that what you must prove? You have to prove that indeed the person what? You know what the court said in Entic and Carity? Entic and Carity. Court said that, the slightest entry amounts to what? Trespass. So you prove that slightest what? Entry. Prove that what? Slightest what? Entry. There is not just enough that what you prove slightest entry. When you say that what somebody has committed trespass, you commit trespass against the person that is in possession. So it means that you, the claimant, you should also prove that you were in what? Possession. So prove that what you were in possession. No. So all those facts are what? Are relevant. They are relevant. They are facts in issue because they help you to what? To prove your case. So what if you ask yourself, why are they in court? What is the dispute? People don't just go to court for the sake of it. Earlier today in court, the court delivered a judgment where the court dissolved what? A marriage. Yes, while I was in court, the court dissolved the marriage. So if they ask you, why are they in court? Of course, there may be several reasons why they are saying this, but the reason they're in court is that somebody is saying that this marriage has broken down irretrievably. I can no longer continue. But that is the dispute, right? That's the fact in issue that the court needs to determine. Has this marriage broken down irretrievably or not? The petitioner that is claiming that it has broken down irretrievably, we now bring facts to show. But what amounts to a marriage being what? Broken down irretrievably, it's also a matter of law. So you have to also check what the Matrimonial Causes Act, I think maybe sections 16 and 51 of the Matrimonial Causes Act, what it says about when a marriage can be said to have my husband for the past 3 or 4 years, he has not had what? Sexual relations with what? With me. Maybe that can show the court that the marriage has indeed broken down what? Irretrievably. So, nobody's not going to ask, why are you, what is the essence of you bringing the evidence that I've not had sex with you? How does that matter? It matters, because the reason we're in court is that I said that what? The marriage has broken down irretrievably. And the court is asking whether that marriage has broken down irretrievably. This is the fact in issue. So, saying that what? Yeah, did not have sex with me is a piece of evidence that helps the court to determine, indeed, whether the marriage has broken down irretrievably. So that is why we say the fact in issue is the fact in dispute. That thing that you need to to prove. All those things that you need to prove for you to win your case, so to say, they are fact in issue. So any evidence that you need to prove those things, they are relevant because they have to do with what? The fact in what? In issue. They have to do with the fact in issue. So now that we have now stated all of this, It then now means that what the next thing is for us to now know. Remember, I said that relevancy is a matter of law. Whether a piece of evidence is relevant or not, we said it's a matter of law. So it now means that what? That we now need to go and interrogate all those rules, all those principles that govern when what? A piece of evidence will be deemed to be relevant. Remember, I said after this, our class on relevancy and admissibility, or our classes rather, on relevancy and admissibility, I said that you should be able to what? To, if I ask you a question, or I set what a problem question, or perhaps in your school they set what you a problem question, and they ask you to determine whether, or to to elicit the relevant facts there. Why you say that a particular fact is relevant, it's not because you think so, or it's not because you feel like it's logical. It must be because you can say this is relevant because section 4 said so, because section 5 said so, because it aligns with what was said in section 6. Oh, this is what section 7 is what it's all about. Oh, this is section 8 that said this is exactly. And it is when you are able to affix a particular fact to any of the provisions of the Evidence Act that you can now say that what it is relevant. That's why we say relevancy is a question of what? Of law. Relevancy is what? A question of law, while admissibility is a question of fact. And that is all I have for you guys what today. So that in the next class on Evidence Act, we'll now start with section 4, 5, and 6, and maybe any other section, depending on how you guys are able to quickly understand them, to determine those rules, those principles on when we can say facts are relevant. Any question?